Hello, my dear students. Today I take a class on court procedure. This is a very important main question for our undergraduate UG curriculum in the subject forensic medicine and toxicology. Now, let me ask you a question. Discuss or describe the procedure of recording of evidence in a court of law and especially criminal court. Now, there are six stages while recording evidence of a criminal case in a court of law. Number one, oath or solemn affirmation. Number two, chief examination or direct examination, or also known as examination in chief. Number three, cross examination. Number four, re examination. Number five, re cross examination, very rarely, and court questions. Judge may ask some questions. Okay. Now coming to one by one. Now let me give a flow chart in brief. Section 2, bracket 23 of Bharatiya Nyaya Samhita. In short, we call it as BNS, which defines both oath as well as solemn affirmation. See, there are two types of people in the world. Number one, who believes in the God, who are known as theists. Number two, who does not believe in the God, known as atheist. Okay. The one who believes in the God may keep his hand on the holy book of his religion, and he may swear in the name of the God that I will tell the truth, the whole truth, and nothing but the truth. That is known as oath. Whereas an atheist means the one who does not believe in the God. Once he does not believe in the God, there is no fun in keeping on any holy book, so he may keep his hand on the chest or maybe on the head. Don't keep on any unwanted parts of your body. And he may say that I solemnly affirm that I will tell the truth, the whole truth, and nothing but the truth. That is known as solemn affirmation. Now we know exactly the difference between oath and solemn affirmation. Both are defined under section 2, bracket 23 of Bharatiya Nyaya Samhita. Remember, just because a person is theist, it does not mean that always he will tell the truth. At the same time, just because a person is an atheist, it does not mean that always he will tell the lie. Both may lie. Lying under oath or solemn affirmation is known as perjury. That is, giving false evidence under oath or solemn affirmation, which is defined under section 227 of Bharatiya Nyaya Samhita and which is punishable under section 229 of Bharatiya Nyaya Samhita. Now you got knowledge briefly about oath, solemn affirmation, perjury, definition section, and punishment section. Now, coming one by one. If at all the question asked, describe the procedure of recording evidence in a criminal court, you have to write one by one. Number one, oath or solemn affirmation. Already I told what is oath or solemn affirmation. Before giving evidence, the witness must swear in the name of the God that I will tell the truth, the whole truth, and nothing but the truth. That is known as oath. That is by priest. At the same time, if a person does not believe in the God, I told it is solemn affirmation. So, in case of an atheist, he can go for solemn affirmation where he says, I solemnly affirm that I will tell the truth, the whole truth, and nothing but the truth. That is known as solemn affirmation. Remember, oath is always compulsory. Oath is compulsory. Oath or solemn affirmation, both are compulsory. Of course, it is not compulsory for a child less than the age of 12 years, and it binds witness for evidence given. That means, if at all he gives false evidence, then definitely is punishable, and it holds the witness. Of course, there is a spelling mistake. It is supposed to be holds. It holds the witness responsible for the consequence of the evidence given. And as I told you, refusing oath or solemn affirmation is punishable. Up to 6 months of imprisonment can also be given or fine. A child below the age of 12 years is not required to take oath or solemn affirmation. That is the first stage. After receiving the summons, you go to the court, you stand behind the witness box, then you go for oath or solemn affirmation. Then comes what do you mean by perjury, which is itself is very important. Short note, I already explained perjury defined under section 227 of Bharatiya Nyaya Samhita, that is giving false evidence under oath or solemn affirmation. If at all this question is asked as a short note, what do you have to write? Definition. After taking oath or solemn affirmation, if a witness willfully makes any statement, after taking oath or solemn affirmation, if a witness willfully makes any statement which is false, that means false evidence, or he does not know but believes to be true. Second point. Number one, the statement itself is false. Number two, he does not know, but he believes it is true. And third part is, again, he does not know, but believes to be false. He is said to give false evidence. That is the definition of perjury. Or in short, what do you mean by perjury? Willful utterance of falsehood under oath. In short, perjury is willful utterance of falsehood under oath or solemn affirmation. Okay. Now, witness is punished under section 229 of Bharatiya Nyaya Samhita. This already I discussed under flowchart, and up to 7 years of imprisonment and fine. Okay, if a person is giving false evidence under oath or solemn affirmation, he can be punished maximum up to 7 years of imprisonment and fine along with that. Why may the witness give false evidence? Why? Why has to give false evidence? Maybe so many reasons, like number one, bribe. He must have been bribed. Number two, threat by the opposite party. Number three, grudge against the party. And to favor the opposite party. Anything. Okay. All these are causes to give false evidence under oath or solemn affirmation. Next step is examination in chief. Examination chief or chief examination or direct examination. It is conducted by the lawyer who has called you as witness. It is examination of the witness by the lawyer who has summoned him. Say, for example, I am a forensic expert. I have conducted a postmortem examination. I have conducted a postmortem examination for the lawyer. So, my lawyer will be the public prosecutor. Okay. So, here, in government prosecution cases, the public prosecutor first examines the witness, as I mentioned. And in private cases, the witness is first examined by the lawyer of that party. For example, in case of murder, trial of murder, the defense lawyer, he will start chief examination for his witness, whereas government lawyer will start examining of government witness. Okay. Now, what is the purpose or what are the objectives of chief examination? The objective is to place all the material facts, what the witness knows, in front of the court related to the case. For example, if I've done a postmortem examination, I'm going to tell when I've done postmortem examination, what are all my findings and what could be the cause of death. All this I'm going to tell in the court of law. I place all the material facts in the court. That is the objective of examination in chief. Leading questions are not allowed. No leading questions. What do you mean by leading questions? I will explain later. Okay. Unless witness turns to be hostile. Hostile witness, hostile witness means adverse witness. The one who gives evidence against the interest of the party by whom he has been called. Such witnesses are known as hostile witnesses. Now, what do you mean by leading question? Leading question is a question which suggests its own answer. Leading question is one which suggests its own answer, where the witness can be answered in the form of yes or no. Yes or no. I give example. Look here. Was the length of the blade 15 centimeters? Say, for example, a knife. What is the length of the blade? Was the length of the blade 15 centimeters? Where he can answer in the form of yes or no. Now it is a leading question. So how the question should be asked? What was the length of the blade? Then I answer 15 centimeter. It is not a leading question. Now you know what is the difference between leading question and not a leading question. Number three, cross-examination. Cross-examination is always done by the opposite lawyer. So here, the witness is examined by the lawyer of the opposite party. What is the object? The object is always, see, the idea of the opposite lawyer is to protect the accused. So he tries to weaken the evidence by proving that the evidence given is inaccurate, contradictory, conflicting, ill-founded, or judice. Only thing he wants to prove to the presiding officer of the court that the witness is not reliable. His evidences are not accurate. It is always contradicting. It is conflicting. It is ill-founded and prejudiced. Okay, always done by the opposite lawyer. Here, any type of questions can be asked, including leading questions. Any type of question, even personal questions not related to the case also can be asked. That is in cross-examination. Okay. No time limit. It can go continuously, 1 hour, 2 hours, it can go continuously. There is no time limit for cross-examination. Okay. Now, here, the defense witness in a murder trial is cross-examined by the public prosecutor because already I told you, in case of a murder case, the lawyer of the witness is the defense counsel. He will be cross-examined by the opposite lawyer. For him, the opposite lawyer is the public prosecutor. Okay. Number 4, re-examination. Re-examination. If at all any new aspects has arisen during the cross-examination, now the same lawyer will go for re-examination. So it is done by the lawyer who has conducted the examination chief or chief examination. As I told you, if at all any new aspects has been arised during cross-examination, all the doubts can be cleared during re-examination. Next, here again, leading questions are not allowed unless the witness is hostile. Remember, leading questions can be asked in cross-examination, means by the opposite lawyer, leading question can be asked by the same lawyer. This cross-examination, leading questions cannot be asked. Okay. No new matter to be introduced. No new matter to be introduced. And if at all you want to introduce any new matter, you should take permission from the presiding officer of the court, that is magistrate or the judge. Okay. Lastly, a recross examination, which is conducted very, very rarely. Again, it is generally not allowed unless a new matter has been brought in re-examination, then recross examination can be done by the opposite lawyer. Again, leading questions can be asked. Leading questions can be asked. Okay, so leading question can be asked only by the opposite lawyer. Same lawyer can also ask the leading question only when the witness becomes hostile. Okay. Court questions. See, the presiding officer of the court, maybe a magistrate or the judge, can ask questions at any time during the trial. The judge may ask any questions to the witness at any time during the stage of trial to clear up any doubts. Any doubts. Now, at the end, the evidence thus recorded by the presiding officer, that means the judge or the magistrate, should be read to the witness and it should be signed by him. Signed by the witness, at the same time it will be signed by the presiding judge and magistrate or magistrate also. Remember that. That is the completion of court procedure. Now, I give you flow chart. As already you know, first is oath or solemn affirmation. After that, direct examination or chief examination or examination chief done by the same lawyer. No leading questions unless hostile. Then comes the cross-examination by the opposite lawyer. Leading questions are allowed. Thirdly, re-examination by the same lawyer. No leading questions unless the witness becomes hostile. Then comes the recross examination by the opposite lawyer. Leading questions are permitted and court questions. Judge can ask questions at any time during the procedure. That is regarding recording of evidence. And in case of main question, maybe for 10 marks or 15 marks, you have to write like this. It is one of the easiest topic. Meantime, I will show you the question. The questions are very important for your NEET page examination. Even INISET also they ask. Previously, AIMS examination they ask. Foreign medical graduate examination they ask. Say, for example, here NEET PG 2019. Perjury is punishable under which section of BNS? Answer is 229 of BNS. A person giving false evidence under oath will be punished under, again, 229. Now, in a court of law, the witness willingly hide this information. That means he has given false evidence. He has not told exactly what he knew. So, he is punishable under section 229, asked in AIMS, November 15, of course, that time it was IPC. Maximum punishment perjury is 7 years. 7 years. While recording evidence in a court of law, the lawyer asked the witness, did you see that Mr. A killed Mr. B? Witness answered, yes, that means it is a leading question. Leading question is permitted only in cross-examination. Cross-examination. In the court of law, examination of a witness is being done to develop new and old facts and to try to weaken the evidence by showing that evidence was biased, inaccurate, inconsistent by lawyer during which of the following? Cross-examination. He wants to weaken the evidence. In a court trial, leading questions are not permitted in all the following. Of course, right declaration not supposed to ask a leading question. Re-examination you cannot ask. Direct examination you cannot ask. Cross-examination you can ask leading question. Leading questions are allowed during cross-examination. You know it. Okay. The examination of a prosecution witness will be done by, I told, who does the examination chief? The same person will do the re-examination. So answer A, public prosecutor. Because examination chief in case of prosecution witness is by the public prosecutor. The defense witness in a murder trial is cross-examined by, already I told you, for a defense witness, opposite lawyer is public prosecutor. So answer A, public prosecutor. Okay. Cross-examination of the prosecution witness is done by, what is the purpose? Cross-examination of a prosecution witness is done by, again, it is defense counsel because for him is the opposite lawyer. Cross-examination by the defense lawyer is done. Why? It is not to confuse the witness. It is not to make judge understand better. It is not to obtain more evidence. He wants to get less and less evidence. The answer is, his idea is to protect the accused. Okay. One of the following examination may act as double-edged knife. See, cross-examination always acts as double-edged knife because they can ask leading question where he can answer in the form of yes or no. It is always very difficult to answer in the form of yes or no. Many times you may need explanation. Okay. Say, for example, once in a court of law, the lawyer asked me, he has brought one lady where had issued a wound certificate some 8 years back. Doctor, by looking at her face, can you recognize her? I wanted to tell him, by comparing the identification marks were written in the wound certificate on her body, I can identify her. When I just started telling, by comparing the doctor, I just ask you a question by looking at her face, whether he can recognize or identify her or not. Again, I said, that's what I'm telling. By compare, doctor, I'm telling you, by looking at her face, whether you can recognize or not, just tell yes or no. That's all. Now it is a double-edged knife. You know why? If I say yes, who is she? I don't know. Because I examined 8 years back. At the same time, if I say no, he will tell, Your Honor, doctor himself cannot recognize. What is the guarantee that he has examined the same person? Then I told lawyer, excuse me, my dear lawyer, for each and every question of yours, I am not in a position to answer in the form of yes or no. Then he started shouting, no, I say it is possible. You may be possible in your case, but in my case, it is not possible. I'm sorry. Again, he started arguing. Then I said, okay, in that case, I will ask you one question. Will you answer in the form of yes or no? I took permission from the judge. Judge permitted. Then I asked, okay, my dear lawyer, just tell me in the form of yes or no. Only one question. Did you stop beating your wife? Was about to tell yes or no, immediately realized it is also a double-edged knife. Did you stop beating your wife? If you say yes, he is beating. If you say no, no. If you say no, he is still beating. If you say yes, he was beating. And the evidence in front of the presiding officer of the court and all other lawyers and bystanders. Then he said, okay, doctor, I'm sorry. Then I told about the identification mark and the case was closed. Okay. That is regarding the MCQs as well as discussion about procedure of recording evidence in a criminal court. Okay. So here the answer is cross-examination. That is regarding this major question. Wish you all the best. Study well. Bye-bye.